सुप्रीम कोर्ट ऑफ पाकिस्तान के सीनियर जज जस्टिस अतर मिनल्ला ने कहा है कि अदलिया को पाकिस्तान के एक मुंतखब वज़ीर आज़म को घर नहीं भिजवाना चाहिए था। जस्टिस अथर मिनुल्लाह ने ये बात न्यूयॉर्क सिटी बार एसोसिएशन के हॉल में पाकिस्तानी अमेरिकन कम्युनिटी से खिताब करते हुए कही। न्यूयॉर्क सिटी बार के सदर उस्मान फरीदी ने जस्टिस अथर मिनुल्लाह को खिताब के लिए मदऊ किया था। इस तकरीब में पाकिस्तानी मीडिया, पाकिस्तानी अमेरिकन कम्युनिटी और चंद पाकिस्तानी अमेरिकन वकला ने शिरकत की, जबकि लोकल सिटी बार के गोरे वकला मेंबरान तकरीब में मौजूद नहीं थे। तकरीब में पीटीआई अमेरिका की आला क़यादत भी मौजूद थी। जस्टिस अथर मिनुल्लाह ने यूं तो कमोबेश 1 घंटा तक इस केस का अहवाल सुनाया, जिसमें उन्होंने पाकिस्तान के साबिक फौजी सदर मरहूम जनरल ज़ियाउल हक की बेटी के पालतू हाथी को इनके बैकयार्ड से रेस्क्यू किया था। ताहम तकरीब के दौरान एक मरहला पर वो अपनी वालदा का जिक्र करते हुए जज्बाती हो गए और कहा कि आज वो जिस मुकाम पर खड़े हैं इसकी वजह इनकी वालिदा हैं। जस्टिस अथर मिनुल्लाह ने पाकिस्तान में अदलिया की आज़ादी से मुतल्लिक भी गुफ्तगू की। ताहम अपने खिताब में उन्होंने सुप्रीम कोर्ट ऑफ पाकिस्तान के बाज़ फैसलों पर तनकीद भी की। इनका कहना था कि अदलिया को पाकिस्तान के मुंतखब वज़ीर आज़म को घर नहीं भिजवाना चाहिए था। न्यूयॉर्क सिटी बार एसोसिएशन की इस तकरीब में सवाल जवाब का सेशन भी हुआ। तकरीब के इख्तितामी लम्हात में एक सहाफ़ी के सवाल पर जस्टिस अथर मिनुल्लाह जज्बाती भी हो गए और उन्होंने न सिर्फ मज़ीद सवालात लेने से इनकार कर दिया, बल्कि तकरीब में मौजूद लोगों को सेल्फियाँ लेने से भी मना किया। तकरीब में मौजूद पाकिस्तानी मीडिया और कम्युनिटी के मेंबरान ने जस्टिस अथर मिनुल्लाह के इस तर्ज़ अमल पर हैरत का इजहार किया। आइए आपको तकरीब का अहवाल दिखाते हैं।
And I will let Kabir give a more proper introduction of Justice Minullah, but what I will say very briefly is that in the last couple of days I've had an opportunity to shadow Justice Minullah as he visited the various courthouses in New York. He's met with a number of judges from our courts, including Judge Elizabeth Strong from the Eastern District of New York, Judge Jimmy Rivera from the New York Court of Appeals, and Chief Judge Owen Wilson from the New York Court of Appeals. And I will tell you that just from listening in on those conversations, it's been quite a treat for me. And there's one thing that became readily apparent to me from those conversations, that Justice Minullah's love for his country, for his colleagues on the bench, that's a paramount thing for him. And most importantly, he has a commitment and dedication to the rule of law. Now I have the privilege of welcoming Chief Judge Owen Wilson from the New York Court of Appeals, the highest court in our state. The Chief Judge will say a few welcoming remarks before we turn the podium over to Kabir and Justice Minullah. We are one of the largest voluntary bar associations in America. We are about 23,000 members strong, and we have a dynamic and diverse group of members who include some of the leading practitioners, judges, academics, and law students from the New York City area, but also abroad. And our mission is to equip and mobilize the legal profession to practice with excellence, to promote the reform of law. And consistent with our mission, it is quite an honor for us tonight to host Justice Athar Minullah from the Supreme Court of Pakistan. Justice Minullah will have what I will expect will be a very illuminating and interesting conversation with my colleague, Kabir Hashmi from Patterson Belknap, who himself clerked for another justice on the Pakistani. Please, Justice Minullah and Kabir Hashmi.
Evening. Thank you, President Freed. It's really a great privilege for me to be here with you this evening and to welcome Justice Minullah to New York. It isn't his first time here, and I had the great pleasure of spending about an hour or so with him this afternoon. He's really a wonderful man, a wonderful jurist. When Justice Khan, chairs the association's Rule of Law Committee, asked me to attend and to perhaps give some introductory remarks, I was under the impression that she asked me to do so because both Justice Minullah and I have written about elephants. And I have to say, he was a lot more successful in that regard than I was. His majority opinion holding that an elephant had rights that were enforceable under the rule of law was met with worldwide admiration. And my dissent in the Happy the Elephant case produced a huge number of headlines in papers, mostly in the United States, that read, "Court holds elephant not a person." But on reading the flyer, inviting all of you here and learning more about Justice Minullah, I realized that his presence here has really nothing to do with elephants and everything to do with the independence of the judiciary. From the flyer, you can see that in 2007, this association held a huge rally in front of 60 Center Street to support the independence of the judiciary in Pakistan at a time when President Musharraf had removed Pakistan's Chief Justice, Justice Chaudhry, placed him and his family, including young children, under house arrest, and suspended the Pakistani constitution. A year later, when Chief Justice Chaudhry was able to come to the United States, the association bestowed an honorary membership on him in recognition of his sacrifices to maintain the rule of law in Pakistan. So just a few months ago, 6 judges of the Islamabad High Court wrote a letter accusing the Pakistani security forces of interfering with judicial decision-making by secret surveillance of judges in their homes, by torture and murder and threats to relatives of the judiciary. In May, the Pakistan Supreme Court heard arguments concerning the charges, and Justice Minullah is today involved in the same efforts to protect and ensure the independence of the judiciary that Chief Judge Chaudhry was nearly 2 decades ago. Even here in the United States, and I think all of you know this, we are facing increasing threats to the independence of the judiciary as certain members of the public, sometimes quite famous ones, are emboldened to attack judges verbally, and others translate that into a license to attack judges physically, including by, in some instances, murdering them. We don't face the level of threat to the rule of law that Pakistan faces, but it's the same in concept. We all need to fight those threats to judicial independence in whatever form they take, regardless of their source, both to maintain the rule of law here and to remain able to set a standard for others around the world and to aid them as we have done in the past. So it gives me great pleasure then to turn the program over to Justice Minullah to hear his words of wisdom. I had a private audience where I learned a tremendous amnt about a variety of subjects relating from the rule of law to tolerance to history to religion. I hope I can remember even half of what I learned over that hour, and to get a little bit of inspiration from him for all of us as we strive to defend the rule of law. And if he happens to stray a bit into elephants, you won't hear a complaint from me.
Welcome, Justice Minullah. Welcome to New York and to the New York City Bar Association. It is an honor and a pleasure, and I feel lucky to be the one to speak to you tonight. I don't want to be the one who talks about your background because I want you to tell the audience. So could you tell us a little bit about your early life, where you grew up, your parents, and gratitude to the President and his colleagues and the members of this very prestigious and one of the oldest bars. And let me share with you that I had no intention of accepting any invitation, but when I received the letter and I saw the name, then I inquired. I was told that this is one of the youngest member of the bar who has been elected, as president of this bar. And I found out that his links with Pakistan and with Sialkot. So I am here today, Mr. President, to give you this recognition that the tremendous achievement you have made in this short time. It's an honor and a privilege for me, and on behalf of my people, I congratulate you. Let me also acknowledge that this great city and this country gave you that opportunity to display your talents and to achieve what very few would have been able to achieve. So that in itself is a recognition of this society, its values of democracy, equality, and social justice. And that is why you are here, you have reached this position. And unfortunately, since from the very early time, constitutionalism in Pakistan could not progress because of interventions by those who had no right to govern the country.
I'd never participated in the bar politics. This was, I thought it was my duty as a lawyer to take up the issue because it was the issue of independence of judiciary. And that is how I joined, and then somehow Chief Justice Athar Minullah, he sent a message to me, but that I will leave for my memoirs, would not disclose it now. An elected Prime Minister was disqualified from his office. That was not the function of the Supreme Court. So many elected representatives were disqualified under Article 62(1)(f). That was not the function of the Supreme Court. And that was not fair to those 90 people who had sacrificed their lives. It was not fair to all those thousands of young people imbued with idealism who had sacrificed their day and night. The Supreme Court and the judiciary was not fair to them as well. General Mohammad Ziaul Haq asked the President of Sri Lanka that my daughter wishes to have a baby elephant. Now, elephants are very, very intelligent social beings, and they have emotions, very strong emotions. They grieve and they rejoice. They celebrate the birth of a baby, and it's a very matriarch kind of a family, you see. So this 1-year-old Kawan, then he was not named Kawan, but a baby, was kidnapped by a state to be offered or gifted to another state. So to me, it looked like it was a case of enforced disappearance. Now, to shut down the zoo, what are children and grandchildren going to do? So I said, why not put our children and grandchildren in these cages and allow people, let them be exhibits as well. And imagine what happens to an animal in the zoo when outside people are staring at him, at that animal species. That is violation of that animal right and animal being's right to dignity as well. So I had to find a way out. So then I realized that when the United Nations Declaration for Human Rights was being drafted, I wanted to know, how did they come with this idea that humans have rights? Do they have rights only because they are humans? Or is there some other intrinsic value which gives them those rights. So I realized that a dead human does not have rights. So why does a living human, a breathing human, whether that's an infant or a comatose or any person on a ventilator, why do they have? So there was another very big difficulty. I read about the jurisprudence. With great respect, the Chief Justice, though he dissented, was about Happy the elephant in Bronx Zoo. And that was the time when I'd almost completed my proceedings. The Supreme Court of New York dismissed Happy's petition. It dismissed Happy's petition on two grounds. One ground was that it cannot bear legal rights and it cannot be accountable for its acts. And the second ground was that since it cannot do that, it's not a person. And the personhood, you see, though the judges were extremely sympathetic towards it. So then I realized why humans have human rights. That factor, attribute, that has the intrinsic value which needs to be protected is that life and life alone which gives rise to all these rights. So then that attribute, that intrinsic value is also there in case of the non-human animals. So then again you see there was a difficulty. The Supreme Court of New York, since they said we can't grant a habeas because it's not a person. So that was again a difficulty for me. And that was the correct approach, because even in our constitution, then I realized that all these constitutions have been drafted by humans to regulate themselves, to protect themselves. That is why they are in the context of only a person. So then I find a way out by way of mandamus. And mandamus because I held that the right to life of humans is dependent on protection of natural habitats, of the ecosystems, and all these living beings. And it is the state's responsibility. So once I held that each one of those 900 non-human species in Marghazar Zoo, when I recognized their rights, then I issued a writ to the government to shift them to sanctuaries. Now there was a very great difficulty. The marsh crocodile was not an animal species which should have been there in Islamabad. So I didn't know what to do. I thought, you see, this is as serious as the human rights violation. So, and I looked at the prayers that were sought. I said, even the prayers are not the way I'm looking at it. So what I did was I appointed the World Wide Fund, Pakistan, as an amicus. To my shock and horror, the amicus brief that they submitted, they said, well, we can improve the conditions. So for me, there was a very, very different kind of thing that, I mean, it was bothering me. Why it was bothering me? I'd read about Otabanga, I'd read about Sergi Batman, and I hope you all must be knowing about Otabanga. Not very long ago, only in 1906, Otabanga was a Congolese native He was brought here in the United States and he was placed in the zoological gardens, which is also known as the Bronx Zoo. And he was then caged along with the monkeys as a human exhibit. What happened with him? I mean, imagine there was a time when humans treated humans as non-human animals. I was optimistic. And why I was optimistic? It was a movement of the people. Those people who we call them the have-nots, who have no access to justice, who cannot afford justice, and who have always yearned for rule of law. But it was, the most optimistic aspect was that it was a movement of young lawyers and the young people. And I saw students from Harvard taking leave only to be part of that movement. I saw the idealism of the youth of Pakistan. And I saw that change in Pakistan for the first time. And as you said, 90 people lost their lives in that movement. They sacrificed their lives. Many were arrested. And again, I would say very fortunately that I was arrested as well and spent some very memorable and good time in the overcrowded prison of Adiala. But that gave me an opportunity to see for myself. Now, when I was the Chief Justice, I received a letter from one of the inmates of Adiala prison explaining to me the horrific conditions within the prison to which I myself was a witness. So I converted his petition into a constitutional petition and then rendered a judgment on the rights of the prisoners and what their rights were and what were the duties, and that also then gave me an opportunity to visit Adiala prison along with all my judges several times. So yes, the lawyers' movement was a great movement, but it never ended there. Let me admit that after restoration, the restored judiciary let down those young people. The jurisprudence that developed after that was not the jurisprudence which was in conformity with the goals of that lawyers' movement. That lawyers' movement was not for the restoration of judges or the Chief Justice. It was a movement for restoration of the Constitution and the principles of democracy, freedom, equality, and social justice that are embedded in that Constitution. But what happened after that? Let me confess, the Memogate case was not a case which should have been taken up by the Supreme Court. It was encroachment upon the domain of the executive. One of our ambassadors, a dignitary, was declared by the Supreme Court as a traitor. I think that was not in the interest of the country. I think for a judge, the starting point or the commitment is the oath that we take before we enter upon the office. That's a commitment to the people, and that is a commitment made to Allah. And that the wordings of each word of that oath has a sanctity. And that is the guarantee for independence of the judiciary and for being an independent judge. If you take an oath that you would fiercely adjudicate whatever matter comes before you, and that you would not favor anyone, you would not fear anyone, and that you will defend, uphold, and protect the Constitution, that is it. Now it depends, you see. Everyone takes oath. How an oath is violated, for me, it is inconceivable.
But there is also an element there of the judgment being worth implementation. The Supreme Court of Pakistan has upheld martial laws, and those judgments were implemented. So could you speak to that a little bit, that when it comes to the rule of law, what is the Supreme Court's role?
No, I mean, this is a very unflattering issue, you see. But we cannot erase the facts from history books. Yes, the Supreme Court's role has been what it should not have been. The Supreme Court has no authority to legitimize any unconstitutional act, let alone abrogation of the Constitution. The Supreme Court is the creation of the Constitution itself. And when the Constitution is violated, and if the Supreme Court fails in its obligation to protect and defend the Constitution, in my opinion, the judges are committing misconduct and they must be proceeded against.
It also has parallels to a current decision in the United States Supreme Court regarding presidential immunity, and I know you're aware of it. What lessons can the rest of the world learn from Pakistan's experience when it comes to presidents who overstepped their bounds or committed acts whilst they were president?
You see, firstly, our Constitution is a parliamentary democracy-based Constitution. So the president is merely a figurehead. He doesn't have any power. So the only immunity is immunity that has been given to the president. So I'm of the view that it is not very significant. But in my opinion, a prime minister was dismissed from his office, an elected prime minister, because he took the plea that there was a presidential immunity. Yes, the presidential immunity was there. And the Supreme Court, in my opinion, with great respect to the Supreme Court, could not have removed and dismissed but unseated the elected prime minister on that ground. So immunity is not there as far as the prime minister is concerned, who has the powers as an elected prime minister. But as far as the judgment is concerned, I think I wouldn't like to comment on that because the chief judge is also here. I leave this to the chief judge, you see. I would be more concerned about my Pakistan, you see, and its constitution. Islamabad High Court. The day I took over, the next day, what was the first circular that was issued by me? Do you know that?
Somehow, yes, I read about that in Dawn.
What is that circular? I want to know from you. You believed the political narrative, but you never, you see, you also doubted my integrity by believing a narrative without knowing the facts. So let me tell you, and probably it's an opportunity to tell you and tell all those who have believed in this false narrative. And no other High Court has ever done that. The day I took over, the next day I issued and that is on record. I believe that Islamabad High Court was a constitutional court and it was its duty to remain open for 24 hours. But in the same circular, I had prescribed the procedure that anyone, no matter what time, wants to file a petition, would call the number, that petition would come to me. If the High Court would always open, the lights would open, because the staff would go to attend to that matter, whether that was 3 a.m., that was 4 a.m. And that circular is still on record. On 5th of July, when General Ziaul Haq was removing an elected Prime Minister, I wish they were open on 12th of October, when General Pervez Musharraf had thrown out an elected Prime Minister. If anyone had attempted to remove unconstitutionally an elected Prime Minister till then, Mr. Imran Khan, then it would have been a test of the Islamabad High Court whether it stands up to uphold the Constitution or not.
I can't take
over the edge, feel like I'm floating through the air. The pain I felt is paid for, all is said and done.